All right, let's dive right into this explainer. Today, we're exploring how British Columbia builds frameworks of trust, accountability, and proper governance. Now, I know what you might be thinking. What do professional lawyers and residential strata councils really have in common? Well, it turns out quite a bit. They're actually both underpinned by incredibly robust legal structures that are designed first and foremost to protect you. So we're going to break down the rules governing the lawyers who defend you and the councils that manage the very roof over your head.
We'll be using a thematic approach today to bridge the gap between lawyering and living. We're going to hit 5 crucial pillars: foundations of BC law, defining key legal terms, the duty of care, navigating conflicts of interest, and lastly, governance and transparent records. Let's get started.
Okay, Part 1, Foundations of BC Law. This is all about establishing trust and accountability.
To start things off, we really need to understand that whether you're fighting a high-stakes case in court or, just trying to get a leaky roof fixed in your condo complex, you are bound by some pretty strict codes. On one side of the coin, we've got the Code of Professional Conduct for British Columbia. This is published by the benchers, and they're the folks who guide the ethical conduct of lawyers, basically making sure the legal profession serves the public safely and effectively. But then on the flip side, we have the Strata Property Act. And this is a massive legislative rulebook that empowers owners to democratically manage their own residential communities. Both of these frameworks, they exist for one simple reason: to replace chaos with predictable, accountable rules.
Moving on to Part 2, Defining Key Legal Terms. Let's look at the language of the rules.
Let's demystify some of this dense legalese, starting with the BC Code. In the legal realm, the word competence isn't just a nice compliment. It is the absolute, non-negotiable ethical baseline a lawyer has to bring to your case. According to the code, a lawyer must have and apply the relevant knowledge, skills, and attributes to appropriately serve a client. Honestly, if they don't have it, they shouldn't be taking your case. Period.
Now, let's bring it back to your home. The Strata Act defines what's called common property. Basically, this is the shared real estate. Think the roof, the lobby, the elevators, and crucially, all those pipes and wires hidden behind the walls. This is the property that everyone in the building collectively owns, and just as importantly, is collectively responsible for maintaining.
Right alongside that concept is your unit entitlement. This is a specific number assigned to your individual strata lot. You can think of it essentially as your financial weight in the building. It dictates exactly how much you are going to pay for those shared common expenses and contingency reserve funds. It's literally the math that makes the whole strata function.
So, an absolutely crucial point here is how the Strata Act categorizes decision-making power. Because as you might guess, not all decisions are created equal. Routine matters might just need a simple majority vote, so more than half of the voters present. But major property decisions, like changing a bylaw or making a significant alteration to that common property we just talked about, those require a much tougher 3/4 vote. And in super rare cases, like say canceling a strata plan entirely, it might require an 80 or even a unanimous vote. The law actually sets this high mathematical threshold on purpose, just to protect minority owners from getting steamrolled.
All right, Section 3, the duty of care, protecting the vulnerable.
Whenever you hand over your trust, or let's face it, your life savings, the law demands rigorous standards. On one hand, the BC Code demands a lawyer provide absolute quality of service, honesty, candor, and strict confidentiality to their client. On the other side, if you get elected to a strata council, Section 31 of the Strata Act spells out your standard of care. You must act honestly, in good faith, and exercise the care, diligence, and skill of a reasonably prudent person in comparable circumstances. You can't just phone it in. You are legally accountable for managing your neighbor's assets.
Just take a look at this quote. It's directly from the Strata Act, and it leaves absolutely no room for ambiguity. If you're sitting on a council, you must put the building's interests ahead of your own. Your duty is to the Strata Corporation as a whole, not to your buddies down the hall, and definitely not to your own wallet.
Conversely, looking back at the BC Code for lawyers, the duty of confidentiality is practically sacred. But, and this is a big but, there is a limit. The code outlines this kind of chilling future harm exception. Basically, a lawyer may disclose confidential information, though only as much as absolutely necessary, if they believe, on reasonable grounds, that there's an imminent risk of death or serious bodily harm. It's a really powerful reminder that while client secrecy is paramount, public safety ultimately overrides it.
Which brings us to Section 4, navigating conflicts of interest, maintaining impartiality. So what exactly happens when personal interests collide with these professional duties? Well, for lawyers, avoiding conflicts of interest is a huge deal. The BC Code is extremely strict here. A lawyer absolutely cannot represent opposing parties in a dispute. They can't act against former clients in related matters where they might hold confidential info. Even in concurrent representation, say drawing up a contract for two business partners, they have to obtain fully informed, voluntary consent. And if a dispute suddenly blows up between those joint clients, the lawyer has to withdraw immediately. They simply cannot pick sides.
Now, in a strata council setting, conflicts of interest are taken just as seriously. Let's say the council is voting on a lucrative landscaping contract, and surprise, surprise, your brother-in-law owns the bidding company. Well, Section 32 of the Act requires three very strict steps. First, you have to fully and promptly disclose the nature of your interest. Second, you must abstain from voting on it. And third, and honestly, this is the one people always seem to forget, you must literally leave the council meeting while the matter is being discussed and voted on. You can't just sit there and try to subtly sway the room. All right, our final section, Part 5, Governance and Transparent Records, aka Keeping the Receipts.
We've talked a lot about trust today, but as the saying goes, trust requires verification. A massive part of this operational governance is the initial birth of the Strata Corporation. The Strata Act carefully choreographs exactly how power shifts from a corporate developer to the actual homeowners. It kicks off with the developer paying initial expenses, then establishing a contingency reserve fund and an interim budget. Once 50% of the units are officially conveyed to purchasers, a clock starts ticking. The developer then has exactly 6 weeks to hold the first annual general meeting. At that critical meeting, control, keys, and financial records are formally handed over to the newly elected Council of Owners. It's a highly regulated passing of the baton. And to maintain that democratic trust moving forward, Section 35 of the Act dictates a dizzying array of records that a strata must perpetually keep. We're talking minutes of every single meeting, up-to-date rosters of owners and tenants, strict books of account for every receipt and expenditure, registered bylaws, written contracts, and massive documents like depreciation and electrical planning reports. Literally every dollar and every decision must be meticulously documented. But all of those records aren't just busy work. As you can see laid out here, the law ensures that any owner, or even an authorized tenant, has the absolute legal right to inspect those documents and request copies. This is the ultimate check and balance. The council works for the owners, and the owners have the right to look at the books to keep their council in check. Transparency isn't just an option here, it's literally written right into the law. So, as we wrap up this explainer, I want to leave you with this to ponder. Whether you're walking into a law firm to hire legal counsel, or just raising your hand in the lobby to volunteer for your building's strata council, are you truly prepared for the heavy weight of these legal frameworks? Because understanding these rules isn't just for the lawyers or the property managers. It is the absolute key to protecting your rights, your home, and your community. Thanks so much for joining me, and keep exploring the frameworks that shape your world.